Welcome to The Explainer. Today, we're diving headfirst into what has become a legal minefield for emotional support animals in Louisiana. So if you have an ESA, or you're even just thinking about one, this is your absolute essential guide to surviving the new rules.
So let's just get right to it. Is your emotional support animal actually protected? Because, as of 2026, the answer might not be what you think. The rulebook has been completely torn up and rewritten, and what worked for you yesterday could get you in some serious trouble today. Yeah, it's pretty wild. A brand new state law plus a huge court ruling have changed literally everything, almost overnight. And what that means for you is that your old documents, the ones you might have right now, they could be totally worthless. Okay, so first up, let's talk about Louisiana's incredibly strict new state law. It's called House Bill 407, and you have got to know what's in it. The absolute heart of this new law is how it legally defines a therapeutic relationship. And let's be real, this was written with one thing in mind, to shut down those websites that sell instant ESA letters. It bans any letter issued without what the law calls a meaningful assessment. And here is the first giant number you need to burn into your memory. 30. Your healthcare provider now must have an established relationship with you for at least 30 days before they can legally write you an ESA letter. So yeah, the days of that single, quick online consultation, they're over. Gone. Oh, but it doesn't stop there. On top of that 30-day period, the law now requires a minimum of that's right, 2 separate clinical sessions with your provider. The whole point is to make absolutely sure the need for your ESA is legitimately established. So let's just lay it all out. This is the exact 4-step process you have to follow. No cutting corners. And that last step is so important. Your ESA letter is a legal document now, and it absolutely must include your provider's Louisiana license number and type to be considered compliant. If it doesn't have it, it's not going to fly. Okay, so you think you've got the state law down. Well, I hate to tell you, but that's only half the battle. Because a federal court case that happened right there in Louisiana has completely flipped the script on the rules for landlords. And this is a big one. It's all about pet fees. For years, pretty much everyone believed that if you had a valid ESA, your landlord had to waive any pet fees, no questions asked. That was based on guidance from HUD. Well, the Henderson ruling came along and just blew that whole idea out of the water. And here's why. In this landmark case, Henderson v. 5 Properties, Judge Sarah Vance basically said, look, HUD's guidance is just that, guidance. It isn't the law. In fact, she called it unpersuasive. So what does that mean? It means everything is now decided on a case-by-case basis, and the responsibility is on you, the tenant, to prove your specific need. So now, if you're asking for a pet fee to be waived, just handing over your ESA letter isn't enough anymore. You have to be prepared to show that the waiver is both necessary and reasonable. The burden of proof has totally shifted. It is now on you. Okay, deep breath. Let's put all of this together into a single, straightforward plan. This is how you protect your rights. This is how you make sure your documentation is completely bulletproof in this new world. This checklist right here, this is your key takeaway. It is no longer enough to just meet one set of rules. Your paperwork has to satisfy both the strict Louisiana state requirements on the left and these evolving federal standards on the right. You've got to check every single box. Now, because of all these new, super specific requirements, there's a huge and expensive trap waiting for people who just aren't aware of the changes. And that brings us to a really crucial warning. Let me be perfectly 100% clear on this. Any website offering you an instant ESA letter for a fee is now selling you a completely worthless document in the state of Louisiana. It has zero legal standing. It will not protect you. And here's exactly why they fail. They don't meet that 30-day rule. They don't have the 2-session minimum. They aren't based on a meaningful assessment. Frankly, these online services are the very reason that the Louisiana Support and Service Animal Integrity Act was written in the first place, to get rid of them. And the state is taking this very seriously. Using fraudulent documentation isn't just ineffective, it can be incredibly costly. We're talking penalties for misrepresentation that can go as high as $2,500 for repeat offenses. That is a lot of money. So with all these new rules and potential penalties, you might be asking yourself, what does this actually mean for my rights as a person with a disability? Are they just gone?
And the answer is a big, resounding no. You have to remember this. Discrimination based on disability is still illegal. The core protection of the Federal Fair Housing Act is still firmly in place. These new laws change how you document your need. They do not take away the fundamental right itself. And if you want to do more, if you want to advocate for clear and fair housing laws for everyone, you should really consider looking into the Louisiana Housing Reform Task Force and supporting their work. So that's our explainer for today. The landscape has absolutely changed, but your rights have not disappeared. Use this knowledge, build your bulletproof case, and make sure that you and your essential animal are safe and secure in your home. You're ready. The question is, are Louisiana landlords